Good afternoon, everybody, and welcome to the FSBPT August Regulatory Hour with Dale Atkinson. I'm Stephen Sugar, and I'll be your host today. And I'm very pleased to introduce Dale Atkinson as he explores where an individual's free speech resides and how can that be regulated, or where does that interplay with regulation for boards of physical therapy. So I've been looking forward to this for quite some time. It's a subject that's very, very important to a lot of regulatory boards, and we'll come across it, if not already, very soon with potentially with our regulatory work. So without further ado, Dale Atkinson, thank you.
Good afternoon, everyone, and I'll add my welcome as well. And Stephen, I can see you, you can hear me, and you can see the slides, right? Give me the thumbs up. Excellent. So let me offer my welcome as well, and some thank yous as I always do. I don't want this to sound insincere, but I will do this with all my presentation with all of my clients, and that is to thank the organization and its board of directors for facilitating and having these regulatory hours. Big thanks to Jeff and the rest of the FSBPT staff for operationalizing these opportunities for us all to exchange information about important regulatory topics. Today's topic is a really interesting one, and it can be quite technical and confusing, but a big thanks to the staff for their operationalization of this. And the biggest thanks goes to all of you who are attending, whether you're a board member, executive director, administrator, staff, investigator, assistant attorney general, whatever role you play. It is an important one. It is unrecognized, and you need to be thanked. And so I will thank you for the important role you play in regulating the profession in the interest of public protection. And so, as mentioned, I'm Dale Atkinson. I don't have a slide with all the client acronyms I represent, but I represent a whole bunch of FSBPT-like organizations and have for my entire career. I'm just delighted to be here. My clients are just like FSBPT. Their membership are comprised of regulatory boards of the professions, and they provide programs and services to those member boards. Most all of my clients develop, administer, score, and maintain a uniform licensure exam program. So just a little bit about me, no funny pictures or anything else there, except for, oh, wait, we do have a funny picture here. So you all get to decide which one of these is Rich and which one of these is Dale biking, mountain biking, and feel free to put something in the chat. And related to the chat right now, you can feel free to chat if you think Rich is in the yellow or if he's in the whatever other color white shirt that is. But I do want you to participate. This is a really, as I've mentioned, kind of an important, complex, technical topic. And if anybody has anything to say, please feel free to unmute. And Jeff and Stephen and staff who are watching, I can't see everybody, but if somebody raises their hand, feel free to interrupt me and let's get questions and dialogue going. But somebody type something into the chat to make sure I know you're listening. You can say hi or anything else, or it's almost hockey season. So there we go. So now we got some people here at least participating. So a lot of this, again, is your opportunities to engage in some dialogue here. So feel free to do that as we move along. And as Stephen mentioned, this is the topic itself. And as I put my little note in there, if we accomplish this, which is what the write-up was, I'm going to be impressed, or I'm going to be surprised perhaps as well, because it is quite a deep topic, and it can get a little bit confusing. But we'll do the best we can. But we are going to address this speech issue versus conduct, and it is becoming probably more and more prevalent, because it's being argued by folks now who are either unhappy with, disgruntled, or don't believe in a regulatory system. And so how does this all come into play in your worlds in physical therapy regulation itself? And so the quick reminder to start with is I'm talking to what I see as regulators, not as physical therapists, not as licensees, not as trade, not as academics, but as regulators. And I know many of you are licensees. And so you bring that expertise to the table. And I'm hoping it can be applied within the confines, at least, of this topic itself. So again, keep those comments coming, keep those chats coming, and feel free to unmute and speak up as needed. But let's get into the topic itself. And I think everybody knows there's this First Amendment, this pesky First Amendment, that protects free speech. And at what point in time does the First Amendment come into play? And not that long ago, we would never see a First Amendment argument being made related to a regulatory structure, a regulatory scheme, and scheme not a bad word, by the way, but a regulatory scheme that the legislature have decided in the best interest of public protection or protection of consumers or patients or the users of service, that we need to create, we, the legislatures, need to create a regulatory structure whereby only those who demonstrate competence and the other requirements are authorized to lawfully engage in the practice. So we all know that, but it's really foundational laying that we have to do, I think, to at least start to address this important topic. So the First Amendment now is starting to be argued more than we would have seen it in the past. And there's a lot of driving factors for these challenges, quite frankly, that I think. And one is technology. And technology allows certain things to be undertaken without this physical presence. And in your world, physical therapy, the word physical in there, does the practice as defined require a physical engagement with someone? And I think the answer is no. And we know telepractice and telehealth and all the issues that are surfacing now start to drive questions of at what point in time words become conduct, or it's not conduct, and it's simply, if you will, words. And so it's easy to conflate the two, by the way, of telepractice and some of the technological advancements that exist with this nuanced question of speech versus conduct. So we'll try to separate that by talking about some of the recent cases that have come up. And the other issue that I think has driven of late this topic, the big picture topic of speech versus conduct, was COVID. And that is government, state and federal, relax certain criteria and standards to try to meet the needs of consumers and patients at a time when being physically together was being either discouraged or, quite frankly, prohibited. And so this relaxation of some of these standards allowed individuals to engage in whatever practices we might be talking about without that physical presence. Therefore, I think placing more emphasis on speech and the use of words, which kind of leads us to this next slide, is at what point do your words become practice? Okay. So it's easier to describe in some professions, perhaps other than physical therapy. I'm not a physical therapist. You all are going to hopefully digest what I say and turn it into relevance in each of your jurisdictions. But lawyers use words, and that's how they make a living. Mental health practitioners use their words, and that's how they make a living, if you will, and provide these services that are important to society. And at what point in time can the ability to profess something through words be deemed to be conduct? Or at what point in time is it words that is subject to First Amendment scrutiny, okay? That is subject to challenge to say your statute at your jurisdiction, at your state, is violative of the First Amendment. So we're setting the stage here for a little bit of this by trying to identify some of these big picture questions that might surface or will surface. So let's dive into a couple of cases, and then hopefully these issues start to surface. But again, I want to emphasize and encourage you to chat or unmute and speak and ask questions to make sure that my remarks become relevant to the physical therapy regulatory community because of, again, how your scopes are defined and what it takes for a physical therapist or assistant to engage in these practices, and where do words come into play or not come into play. And so I'm going to go back to this slide really quickly here and identify some of the legal issues. Now, this isn't supposed to turn you all into lawyers or anything else, but it is important for you to understand that if certain rights are challenged, speech being one of them, the burden to uphold legislation that affects that right may be higher. So I'm going to explain to you the three burdens that exist, or the evaluations that are undertaken by the courts to determine whether these statutes survive this constitutional challenge itself. So one is, and the highest standard is called strict scrutiny. It must be shown that this legislation, that there's a compelling government interest at stake, and that the legislation is narrowly tailored to meet that government interest, okay? And this all, you're going to forget, when I go to the next slide, you're going to forget everything I said probably, but at least understand strict scrutiny, the highest burden to prove. There's intermediate scrutiny, which the actions of this legislation further an important government interest. And what does that mean? This is going to all be case by case again, but it depends on what interest is at stake. Strict scrutiny, intermediate, and then a rational basis. And a rational basis is the lowest, if you will, the easiest standard to meet, that is that the legislation is rationally related to a legitimate government interest. And that's a much easier bar to cross than the strict scrutiny, and it all depends on what right is at stake. So just a little bit of burdens 101, legal 101 related to our topic. So just keep those in mind as you see some of these next slides. Now, I've already mentioned that mental health services is one of the professions that is probably most conducive to a First Amendment challenge, because words are being used as part of the therapy between the practitioner, the licensee, and the patient or consumer of that service itself. So in this particular case, and this was in the height of COVID, by the way, that this was followed, an internet practicing counselor licensed in Virginia challenged the District of Columbia licensing requirement under the First Amendment, arguing speech. So it's kind of setting the stage for what we've already talked about. And this internet practitioner was located in Virginia, but seeing clients from Washington, D.C. via technological means, the internet. And as we all know, look at the advancements that are made. We can have this conversation today between all of us. There are 35 people on the line today, and interact with each other using words. So here, this internet practitioner wanted to continue to treat her patients who moved from Virginia to Washington, D.C. And there was a particular patient of mine that stimulated this, but and the question was, well, does this internet practitioner need to be licensed in Washington, D.C.? So she argued that the D.C. licensing requirement that addressed and required her to become licensed to deal with this internet technological practice violated the First Amendment. Hey, this is speech. This is simply speech that I am providing, which again, I think individuals who make these arguments diminish their own professions by trying to say something like this is simply speech. Or if I were giving legal advice right now to you via the internet, it's just speech. It's not legal advice. I mean, these are really difficult lines to draw and to figure out where they are. Now, the District of Columbia filed a motion to dismiss this case, and the court held that the activities of the counselor constituted speech, and thus must be evaluated under the principles of the First Amendment. And that's that, if you will, strict scrutiny analysis that we just talked about. So there's a hurdle that has to be cleared, and it is a very high hurdle, at least according to the district court here in the District of Columbia. Now, part of the stimulus behind this case, I believe, and because the plaintiff argued this, was this COVID executive orders that waived licensure for telepractice and allowed certain things to occur during these declared emergency times. And then once you remove that requirement, it becomes hard to reinstate it if everything has been going fine, so to speak, assuming you can make that argument. So I think the stimulus behind the plaintiff here, Brokamp, in part was, I've been doing this now during COVID, and now you're reinstituting this requirement that I must become licensed in DC because my client is in DC, even though I'm located in Virginia, and I have a license in Virginia in good standing. Excuse me. So I think COVID stimulated at least some of these cases. This one, perhaps in particular, this case lives on. I don't know the status of it as we sit here right now. I tried to find it, and I'm not sure, but the motion to dismiss was denied. So the case has survived that initial motion practice. The same plaintiff, by the way, had the same issue dealing with clients that moved to New York, made the same argument in New York that the licensing requirement required in New York State violated the First Amendment, just like the DC argument. But here, the court granted the New York Department of Education's motion to dismiss, finding that the counselor, the plaintiff here, lacked standing because she didn't even apply for a license. She had not applied yet, so there was no, if you will, denial of a right to engage in this practice by not granting a license. There were some sovereign immunity arguments made in this case too, but the heart of it related to First Amendment issues, was driven by a standing issue. And this plaintiff could apply for and receive licensure in the state of New York. Now, excuse me. Now, this was appealed to the Second Circuit, which affirmed the district court's dismissal. And here, the appellate court focused on the endorsement statute, saying that this plaintiff, this counselor, would have been eligible to receive a license via endorsement and not had to start over from square one as an initial licensure. And so, therefore, the Court of Appeals affirmed the district court. And in general, if you will, the summation of it is it's a failure to state a plausible claim for relief here because she was eligible to get licensed. So in a sort of backhanded way, the Second Circuit is recognizing the licensure statute. We're somewhat avoiding the First Amendment argument and driving this plaintiff back to the process of trying to get licensed first. Then perhaps you're going to make your arguments of being wronged, of being of a violation of the First Amendment or other statutes that might exist. So we keep our eye on these Brokamp cases. I do work with the social work group and psychology and others. So I work with the mental health community, and we do keep an eye on these types of cases. Now going back a few years, and Pickup versus Brown. Brown was the governor at the time of California. California enacted a law, the legislature, prohibiting sexual orientation change efforts to minor patients. Okay, and so this was challenged under the First Amendment speech-driven issues. And here the court granted California's motion to dismiss, finding that the statutes prohibit treatment or conduct and only incidentally limit speech. And under that rational basis test we talked about, it survived. There's no violation of the First Amendment. So in this case, the court is clearly saying that this is a conduct-driven issue. And I might not go as far as to say it's not subject to First Amendment scrutiny, but we're heading in that direction. So conduct versus speech. Here we find that that efforts here related to sexual orientation is conduct, efforts to either prohibit that or allow that, but in this case, prohibit it, was conduct. And that's part of practice as a practicing mental health therapist, if you will. So here's a conduct case. So you can see we're heading toward having differing views, differing opinions by differing courts, which eventually will have to be determined perhaps up to the U.S. Supreme Court or otherwise. And so again, there's enough activity going on that will stimulate, I think, some of these changes. And/or, by the way, this stimulates legislative changes as well. So turning to a 2022 case, Otto versus the city of Boca Raton down in Florida. Here we have identical ordinances adopted by the county and city, again, prohibiting any counseling practice treatment performed with the goal of changing an individual's sexual orientation or gender identity. So these are prohibitions, not allowing mental health practitioners to engage in this conduct. And prohibiting speech, of course, can be argued on which side of the equation you fall on, but here this prohibition is a limitation on one's ability, arguably, a limitation on one's ability to exercise their First Amendment free speech rights. So there's an exception to this, these ordinances and this related to county and city that allowed counseling that provides support and assistance to a person undergoing gender transition. And this exception became pretty important, and you're going to see that in the next couple of slides. So these ordinances were challenged by a couple of marriage and family therapists. They argued they had sincere religious beliefs. They sought to live in congruence with their faith, and saying this limitation violated their First Amendment rights. Now, the first question we're going to ask ourselves here is, can a county and/or local jurisdiction, city or village, enact an ordinance that affects the scope issues that are enacted through state legislation? Okay, so you're going to ask here in this, as you see in the slide, do the state statutes intend to fully occupy the regulation of the profession? The answer to this question should be yes, or you're going to end up with a hodgepodge of local ordinances. And to maybe drive the point home, several years ago in California, ordinances were being enacted by cities that prohibited the declawing of cats unless there was a medical reason. And this was driven by cruelty to animals and other issues, but this was being done by a city by city or county by county process. And eventually the legislature had to clarify that regulating veterinary practice is a state issue and it's preempted. You cannot create these home rule driven patchwork of prohibitions or allowances based on a scope of practice. And that only makes sense, that I could drive across the street and have something done that I couldn't have had, 50 feet across the street because I went into a different city. And so this is a really important question, perhaps unrelated to speech versus conduct, but you can see here some of the cities and counties may step in on politically charged issues like orientation change efforts and otherwise. So now back to the relevance of speech versus conduct. The court here found that the restricted activities to be speech subject to First Amendment strict scrutiny, the highest, this is the district court, by the way, the highest burden. And the 11th Circuit reversed the district court, remanded it to enter a preliminary injunction prohibiting the enforcement of the ordinances. And the government must prove that these restrictions are narrowly tailored to serve this compelling interest. So here, the court was treating this as speech, in spite of it, again, being related to conduct in the services of mental health. Now, the court here, the appellate court eventually, speech is speech. The professional setting of the speech does not transform it into conduct. So here's a very strong statement being made by the 11th Circuit. I think I might have said 2nd Circuit earlier, the 11th Circuit. And the government, as you can see in that third paragraph, the government cannot be trusted to prohibit only bad speech. Now, how important is that in the day and age of election years, COVID, anything you can think of, is how does government step in and regulate certain words that might want to be said by individuals, especially, like I said, during COVID. We're going to see a slide in a minute. The court also noted here, and this is the 11th Circuit, that there's no consensus on the alleged harm that may be caused by these sexual orientation change efforts that might be granted. So you can imagine now in the world of mental health, the uncertainty of statutes like this, and legislatures are trying to step in and either regulate it or not regulate it and take action. And we have a very hodgepodge, if you will, if I could use that word again, of judicial opinions that are coming down on different sides of this particular issue. So important case, good reading for the lawyers that are those that are interested in this related to this topic. Now, Hines versus Purdue is a case that has been going on for over a decade, and it deals with a veterinarian who practiced for 40 years with a license, etc. He had some health issues that required him that would not allow him to engage in the physicality issues related to veterinary practice. So he opened a practice that was intended to be online only. And it started out as a complimentary. There was no charges involved, but it grew enough where he started charging his patients / clients. And in veterinary medicine, you have a patient, the animal, and the client is the owner, if you will, of the animal. And his practice grew. He's in Texas. And as I recall, I may have this wrong, but as I recall, he had virtually no Texas clients. These clients were all over the US and some, by the way, internationally. And let's not even go down the international road just yet, but just around the US. And so the question became, is he engaged in the practice, first off? Two is, where is practice occurring? And how are we going to differentiate all this? He argued, by the way, that he was engaged in speech, not conduct. So in Texas, the law requires a physical exam of the animal to establish the relationship between a veterinarian and the client and patient. Okay. It's a hands-on physical exam that it must be undertaken. So that's in the law itself. Hines, the veterinarian, sued and said, you are limiting my ability to engage in free speech. This case went up and down so many different times. You're looking at the final decision, if you will, by the district court after remand multiple times from the appellate courts on a host of issues, a host of technical arguments. But in the end, the court now, and this case is over, if you will, over. The court said that the physical exam requirement regulates alleged speech. Okay. This regulation is content neutral. So therefore it's subject to this intermediate scrutiny rather than the strict scrutiny. And although the exam requirement is generally directed at content as applied to the veterinarian, the board is directing this exam requirement to prohibit his speech. And the exam requirement applies neutrally to all forms of veterinary care and veterinary speech, and it's not restricting his speech related to subject matter or topics or otherwise. So it upheld the regulation that required this physical encounter, number one, and number two is it found that the statutory scheme that exists did not violate Dr. Hines's free speech rights. So there was a whole lot going on in this case. And again, I hope people understood that. Type something in the text if you thought, what a great explanation that was, or if I'm so confused now, I have no idea, but let me know if we're heading in the right direction. So again, this case has been going on for a long, long time, and it has been up and down numerous occasions, but in the end, the speech issue, if you will, was defeated, if I could put it that way. And I say that with all respect to Dr. Hines. This case is again from 2022. It's back to the Florida Department of Health, and an individual seeking to engage in work as a dietitian argued that the licensure statute violated his First Amendment rights, and that he should be able to engage in this kind of inquiry and engagement with his customers about their habits of nutrition intake and otherwise, and that any prohibition of that and a requirement that he can become licensed violates his rights of free speech under the First Amendment. Here, the Court of Appeals affirmed the lower court, which had granted summary judgment. Summary judgment just means that the court knew that there were enough facts that were not in dispute that the court could make a decision under legal principles. So the Court of Appeals affirmed the lower court, which had dismissed the case and had found that the dietitian's licensure statute regulated conduct. So now we're back to conduct and only incidentally burdened speech. Thus, here the court said it was not subject to First Amendment scrutiny. So we could have an argument here about if it's strictly conduct, if it's a combination of conduct and speech, and if the First Amendment even comes into play or doesn't come into play at all. So with that said, now if anybody wants to unmute and talk a little bit about physical therapy being provided through a means where there is either no physical presence in the same room or physical engagement, and it's words only. And I understand that occurs, and I understand that technology is in part allowing that to occur. But we have to understand now, what are we regulating? And is it speech, or is it conduct, or is it going to be some kind of a combination? So if anybody wants to unmute and engage in discussion or type something in the chat, that'll help us stimulate some added engagement. But I'll talk about the slide while you all are thinking about that. So while COVID was going on, a lot of things were being said, both by the media, by practitioners, by licensees, by consumers, and others who had opinions, by presidents and presidential candidates and everything else that was going on. And I find this to be a pretty interesting article. It's from 2023. Doctors who put lives at risk with COVID misinformation rarely punished. And this article, I should say, goes through the arguments of misinformation being spread and that perhaps one's license should be at stake, and very few medical boards are taking action based upon this misinformation. So we have to decide at some point, well, what is misinformation? And where does the First Amendment ultimately kick in? And you all, as the regulators, where do you step in now and say your conduct, your speech, your actions, however you're going to define it that way, constitute misinformation to the point of your license should be at stake? And this is a very difficult question. At least for me, it's a very difficult question, especially during COVID, when we were talking about things that we weren't sure of yet, we, the medical community and everybody else. So good reading here to at least understand what medical boards were grappling with when it came to COVID, misinformation, and then eventually disinformation. Are we talking about that? So someone just typed in, you see Canadian regulators taking action on misinformation regularly, and Canada doesn't have a First Amendment, but they do have some speech rights. So it may be a little bit different, but these are really good points that some folks are making here. And I'm going to scroll up, if you'll bear with me for just a second, on right to practice. I'm going to read a couple of these comments. Right to practice the healing arts is privilege granted by legislative authority, not a right of the individual. So that's an interesting point there. Who typed that, JTH, as to whether practice is a privilege or a property interest, and that might dictate the rights that are wrapped around the license that is either granted or denied. So an interesting question that might be brought up related to any legal arguments that could be made. And then I see a Kansas Healing Arts is entitled to broad and liberal construction. And so speech related to a licensed profession is not tightly constrained by constitutional rights involving free speech. So if I'm understanding that correctly, there may be some arguments here about the Constitution and the First Amendment vis-a-vis the right of the states to regulate. And those are the arguments that we just talked about, all these cases that we just talked about. So again, thank you for these comments. But is anyone confronting any issues related to speech and information that is being given that you can talk about in your boards that you want to either put in the comments and or unmute and speak about it? Is it coming up in a licensure setting whereby complaints might come in, number one, or the board may be made aware of statements, words, positions that are being taken by licensees that might subject that licensee to an adverse action?
So, Mr. Atkinson, I can speak in Kansas that during the early days of the COVID epidemic, we did have complaints and were prepared to take action about COVID misinformation being spread by our licensees. In a couple of cases, we were able to do that where it involved advertising related issues. However, our legislature passed an immunity statute that effectively shut down all regulatory actions involving COVID of any kind. Since that time, that immunity statute has lapsed. However, we really haven't had the kind of complaints that we used to have related to COVID. We don't really have a lot of people in Kansas, trying to exploit that situation any longer in the same kind of ways we saw during the pandemic, for what that's worth.
I appreciate it. Thank you for those comments too. And so the immunity statute only applied during the probably declared emergency, or it had some limited scope of immunity?
It was time limited, and then when it came back around during one of the subsequent sessions, it wasn't pulled back up. So
got it.
We have divided governments. We have Republican legislature, Democratic governor, so it just didn't make it through the second time around.
Got it. Where I struggle with is defining what is misinformation. If you're going to challenge my right to have a license because of something that I am promoting, you better have a real basis for determining that what I say is deemed to be misinformation. It could lead to harm. It's outside of the scope. It's not within the standards of practice. It's not recognized. However you're going to land on that misinformation is a really difficult question that I think that ultimately might have to be established, or if you will, proven to that point. So thank you, Kansas, for those comments.
Ask him just one last comment on that, and I'll mute myself. But those kind of cases require expert testimony, just like a standard of care case. So you have to get a doctor who makes the expert qualifications. Like in COVID, we had expert epidemiologists who could provide that kind of evidence. And then the burden is on the other side at that point to show that their statements were somehow truthful, or at least within the scope of professional practice. So yeah, those cases aren't easy and the burdens need to be met, but they're certainly not impossible by any means.
Right.
So, thank you.
Right.
Thank you.
Sure. Appreciate it. And don't worry about speaking up. The issue of increased knowledge over time using COVID as continuing as our example also might have indicated that certain things that were identified as misinformation may have been more true than we thought to begin with. And so, again, that's why I think I found this article to be pretty interesting related to that. But, those are good points. You do need expertise. And when it comes to an adverse action, just as a quick reminder to everybody on the line, the burden is on the prosecuting side, the board or the department, to show that there was wrongdoing that substantiates the removal of or an adverse action against a license. So yeah, you're going to need this expertise to show that. And it's not always easy. It's not always easy. And some of these cases, by the way, are still going on. There's a couple up in Maine dealing with doctors and who are accused of this misinformation, driven issues. And the charges were pretty recently dropped because I think the board realized that this is a case that could be difficult to prove, if you will, and potentially precedent setting as well. So
I had a case in Minnesota I'm aware of an individual at a school board meeting, and they pontificated after they identified themselves as an expert as physical therapist on mask wearing of children, how it was child abuse, it caused hypoxia and brain damage, and made a bunch of extraneous comments. but they cited their profession as a physical therapist multiple times throughout that discussion for that. So that was a fairly significant challenge at the Minnesota board during the COVID epidemic. So,
did that, and to the extent you can talk about it, did that result in an adverse action?
it resulted in a um, a collaborative approach of the individual reviewing what professionalism is and educating themselves on professional conduct, as well as reviewing some of the information related to the statements that he made and citing and looking at other sources of information. Essentially, it was an educational um, activity for the individual to review on. Nothing in terms of adverse action for against the individual, but more of we'd like to partner with you on helping you understand what professionalism is.
And that somehow was negotiated into a resolution of some sort.
Yeah. Yeah.
Interesting. Other examples? Anybody else want to say something that you've encountered? I'm going to go to the next slide here while we continue to think about that. So what have we learned? And again, I hope we've all learned something out of this time we spend together. I know that I have learned that the courts can come down on different sides of the same issue. And when I say learn this, it's probably not new, but this has helped highlight it. The courts can come down on different sides of the same issue, depending on which court you're before. And that may be stating the obvious, but I think the point of all that is there is no bright line test and there's no easy answers that exist out there. However, with all of that said, your jobs as regulators is to regulate the profession in the interest of public protection, is to act in a manner consistent with the intent of the legislation. And you may be confronted with issues like this, like Minnesota just described. If complaints came in, what are you going to do with them? And I think, I'm hoping that we as regulators have a little better understanding of differentiating between conduct and speech, and how this is really a very difficult question that implicates fundamental rights, within the First Amendment itself. And so, other questions or comments that might surface anyone wants to make?
A question that came up, Dale, was digital health or digital comments on digital platforms or web pages or Twitters or things of that nature. Anything on that?
So, that's similar, Stephen. I guess Nancy had asked that as well. And that's probably similar to if I stand up before a body like a school board and profess to be an expert because I am licensed as a physical therapist, and now I profess, some, standing and some, position on a matter. Is that different than if I'm on social media, just as Dale? I don't identify myself as a physical therapist, and I say, that COVID stuff was all made up and it was all a big conspiracy theory. Where do we all get to step in? Where do you as the regulators get to step in, or must step in, or should step in? Because consumer protection is at stake, and this falls within the scope of what your authority as a board is. That's a really difficult question. And can I separate myself as a licensee from a person who has a TikTok account that is just posting a lot of stuff? I don't know the answer to that until such time as it crosses a line that says, well, as a physical therapist, Dale is here to tell you that, and then I profess to, if you will, give certain kinds of advice, let's call it, even though I'm giving it now into the ether and not to a specific patient or client. And now the board says, whoa, we have to put a stop to this. And I think somebody earlier had mentioned advertising. I wrote it down. That's a really good example of what can I say in advertising? What can I not say? It's probably a better way to approach it. If I'm actually advertising as a lawyer, let's say, And at what point in time does my right to speech be curtailed because my advertisement is violative of whatever the law prohibits? And so I think lawyers, and I think we have a few lawyers on the line, feel free to type in the chat, can't call themselves experts, right? You're not an expert. You happen to have knowledge in your license to practice law, but are you an expert? Am I an expert in patent matters or something? And so there may be these limitations that can be placed upon professions lawfully in an advertisement-driven situation that do not violate the First Amendment. But not that long ago, we couldn't advertise for beer and liquor and legal services, newspapers or on TV either. So, the evolution of this concept of First Amendment protections is obviously ongoing. And I really think it was emphasized through that article that I had cited and through COVID and other things where there are big different opinions that might have existed. So I'll scroll up and look at this as a text as well. So we do have a couple minutes left, but if anybody has anything else to say, we've got some advertising, advertisement issues in the chats. And Jeff, I think you can save these chats, so feel free to do that. We're a strict adherence to truthful advertising. So we have to decide what's truthful, we have to decide what's misinformation. By Healing Arts licensees, since practice of puffery established in non-professional advertising had no place in advertising professions. These are really hard standards to meet. Again, I know we're using very few words in the chat, but these are difficult standards to meet. So, other questions or comments? So we may have covered something, a very difficult topic in a little shorter period of time, and we probably could have spent hours on it. But are you aware of any cases of healthcare professionals who may have had action taken based on discriminatory statements made against patients or groups? Yes, I am. And so, Karen, you can email me, and I can probably quickly locate a couple of those cases. They dealt with human medicine, with doctors who made comments and statements derogatory to certain patients that were premised upon the identity of those patients, and it did lead to an adverse action. So again, here's another example of at what point is speech now able to be regulated or subject you to an adverse action. So Karen, feel free to shoot me an email, or you can shoot it to FSBPT. They can send it to me, and we can post a case or two for you. Other questions or comments? And if not, I'm going to end my session like I started it, with a big sincere thanks. Thanks to the board of directors, FSBPT, you guys rock. Staff for operationalizing this, but the biggest thanks goes to all of you for attending, spending a little bit of time here today, digesting a very difficult topic. But you need to be thanked for the important role you play in public protection through enforcement of the Practice Act. So I will turn this back over to Stephen and Jeff for any final comments.
Great, thanks. Thank you, Dale. Thank you so much for your energy and your bringing forward this difficult topic to talk through, and hopefully it stimulated some neurons for people to be thinking about when this most likely will happen and occur at a jurisdiction near you. So thank you for that, Dale, and we'll go ahead and we'll end this month's regulatory hour, and thanks everyone for their attendance. Bye-bye now.